is Monday, April 27th, 2026. It's approximately almost 2 p.m. and we are located in Cedar Bluff, Virginia. And the purpose of this meeting today is to look at case docket number for this informal fact-finding conference is IFFH 1040. This hearing again is being convened under the Virginia Gas and Oil Act, Section 45.2-1637, which allows to objections to permit application be filed with those standing as specified under Section 45.2-1632. Objections under the statute have been filed against the permit for Pocahontas Gas LLC, coal bed methane well F37A, application number 64170. Objections were filed by Mr. Eric Conley on behalf of Diversified Production LLC as the royalty owner. The objections were filed in a timely manner as required by Section 45.2-1637. Notices to the parties regarding gas and oil operation and the protection of the environment are important elements of Virginia's law. Today's hearing is a part of that process. Question is, there were notifications sent to all parties to appear before this conference as required by Section 45.2-1637G.
Yes.
And did that notice include the date, time, and place of this conference?
Yes.
Okay. For each person who plans to testify in this conference, please state your name.
Mr. Scripper, before we do that, I need to make a couple of motions. First motion I'm going to make is that this item be dismissed. Apparently, we're now finding out for the first time today that there's been some sort of amendment to this permit application. In the informal conference that immediately preceded this one, we learned that Pocahontas Gas reportedly filed an amendment or sought permission to file an amendment on Friday. To my knowledge, that's not been ruled upon. I received, unlike I think every other filing that I have seen before the board over the last 10 months, I received no email. My clients received no email. I heard in the last conference that there may have been a mailing. We have not received that. Apparently that happened Friday. As you know, my office is in Grundy, and unless it was overnighted to me, and even then I would not have been able to receive that before I left my office this morning. So the appearance is that this was calculated to bring us over here and have us prepared on one application, and then basically change the tenor of what the hearing and the application would be like. And I agree, a notice is an important element of these proceedings. And that's not real notice right there. Notice is more than getting halfway through a proceeding and then alerting the parties that the underlying pleadings have been changed. That's the antithesis of fair notice. And if Pocahontas Gas is going to allow parties before us and attempt to do so here, get into a hearing and then raise the issue of an amendment, it's too late. Every court, every tribunal, every hearing that I've ever appeared before, when it comes time for the trial or the hearing or the conference, you proceed on what's been accepted and filed, not on the amendment that you hope to get filed. So that's putting the cart before the horse. That's building the roof before you build, or putting the roof on before you build the walls. All the parties need to know what the particular pleading is that we're here on today. And by statute, that's an application. And by statute, when a party files an application, your honor has to have a hearing, unless the parties agree otherwise, no less than 15 days after that application is filed, and no more than 30, as I recall. So the statutory framework contemplates that once someone gets an application, they have some time to process that and evaluate that. 15 days, and that's what we had, and we used that time. The parties, we hired a surveyor. He disclosed the survey. We disclosed our objection. We reviewed everything. We reviewed where the proposed well location might be. I don't know how much of that has changed today, but I know this, we need time. If we're going to be asked to defend against the new amended application, the first thing that needs to happen is if you're inclined to do so, you can grant the motion to amend their application, and then we get 15 days. If you don't want to do that, if you want to deny the amendment, then we can proceed today on what's before us. But we can't do both. We can't defend on the pleading that we don't know which one it is, and one of which I haven't even looked at. I haven't had my surveyor look at it. I haven't asked Coronado to look at the well location. The other 35 people that got notice of this application, I bet you they haven't been noticed either. So you've got all kinds of problems if you proceed right now, and they're all created by Pocahontas Gas. So don't let Mr. Swartz confuse you here. This is not anybody's fault but theirs. He could have called me on Friday. He could have sent me an email or text. There's a reason he didn't do that. So it's not fair to hold that against Pocahontas Gas and the other people that were entitled to notice and review this. I can't tell you whether I'm going to object to that or not, or how I might defend that case, because I haven't seen it. My team hasn't seen it. No one has seen it. To the extent that you have started a hearing today, and we haven't called any witnesses, so maybe you haven't, but if you have, it's too late to grant their amendment. The thing to do is dismiss the case that's hereupon and let them refile. That's what should be done. And the alternative, if you want to continue this case, that's fine too. I can tell you this, the thing that should not be done, because it's going to violate all the notice requirements that y'all have to follow, is to proceed to hear evidence today without the parties knowing which operative pleading we're here on, which we're entitled to have. And there's really no reason we shouldn't have had this. He has known for months that we were objecting based on where the location of the well was. So that's continue it for, I think you ought to dismiss it. But if you don't want to dismiss it, allow him to amend it and then set it for hearing 15 to 30 days out. He's going to have to renotice all of these people. I don't know if he sent that on Friday or not. He can answer that, but you got all kinds of notice issues. This case does not need to be presented today for a final ruling on the substantive issues. That is clear. So we do ask you for a ruling on the motion to dismiss, and to the extent it's necessitated, on the motion to amend the application before we proceed further. So that's for right now.
My response is fairly brief, but as follows. Diversified's objections to this permit application and the next two that we have on for this afternoon, none of them involve objections as a surface owner. My understanding is the only thing that has changed in the modification that we filed is the well location. Okay. So obviously we're not talking about royalty owner interests, which are the objections that they've made previously. We're talking about surface objections. I anticipate if I just left it at that, I would hear that the change of the surface location needs to be something that they need to look at as well. So I guess my response is, first, we have a right to file a permit modification. We don't have to seek permission, and we have filed that. You have received it. It has been mailed to everybody. My understanding is that the post office has it waiting for pickup by Diversified. On the other hand, it's, last minute, I acknowledge that. So my suggestion would be that you continue this hearing, give parties an opportunity to object further if they wish to do so, within 15 days of receipt of the new mailing, which has been mailed to everybody. And we'll come back, if there's if there's a continuing objection, by Diversified and or, by Buchanan on the F37A unit. But we're good to go on the G objections this afternoon. We could just move forward to those.
Mr. Street, do you have any comments at this point?
Well, I mean, I don't have anything that I'm going to tell you that's not a repetition of what I said before, but I think, as I understand it, Mr. Schwartz is now asking for a continuance of this case. And he would rather you do that instead of dismiss it. And I've asked you to dismiss it, but in the alternative, if you say no, then I've asked you to continue. That's where we are. And so I think both parties agree that the merits should not be heard today. It's now up to you whether you want to acknowledge or grant the amendment. I'm not aware of some unilateral right just to amend pleadings. I mean, if there's a rule that says that, I don't know them all. But it seems to me that you would need to make a ruling to allow the amendment to the application, if that's the way you're disposed to do that. And then, as he suggested, continue it for 15 to 30 days, or we can work together with you on scheduling. But I do stand on my initial objection, which is it needs to be dismissed because the circumstances are a bit extreme here. We went to a lot of expense to hire a surveyor. You started one hearing on the application that was before us before they even whispered the idea of an amendment. It was like a gotcha at the end of the evidence. I mean, this is not, what you normally see in litigation. Let's let someone put on all the evidence, and then at the very end, we're going to pop the amendment if it doesn't look like the evidence is going great. I mean, it's kind of extreme. And because of that, I think it is appropriate to dismiss it, make them refile it, which is really no different than what they did on Friday. The only difference is they would have to back up and notify all of the interest holders, which to me seems like the prudent course anyway. So maybe it's a slight distinction without a difference if they notice everyone, whether you call it an amendment or call it a new filing. But I know one thing, one of those two things needs to happen, and I'm asking you to dismiss it. Mr. Schwartz is asking you to continue it, and I guess set it down for hearing on the amended version.
Well, we've already mailed the modification to everybody. Everybody's going to have 15 days from receipt of that modification to file an objection. So what I'm suggesting is we don't have this hearing today. We wait for the time to expire for people to object upon receipt. And then we come back if people continue. But I'm expecting perhaps that Buchanan Energy will acknowledge the change of location got off of their surface, and we may not have an objection from them. But it's up to them to look at that. What I'm hearing from Mr. Street is he's got objections that are not resolved by changing the location, and he's definitely going to continue to object. But the issue is, I think, a notice issue. We've mailed to everybody. Everyone has 15 days to object or not object, and we need to wait for that to happen and come back. And if there are objections, we'll address them.
Okay, at this time, I request to take a recess for a few minutes to discuss this with staff. Rethinking the testimony that was presented, they wanted both of these deal with F37A. And thinking it further, I've heard the evidence, I'm going to rule on F37A in both cases, Buchanan and for Diversified. I am going to dismiss both of those today. On the other part of it, due notification, you have 15 days from receipt of notification to refile objections. That's my ruling. If I need to do a written decision, I can, it's fine, or we can take this and go on.
I don't need a written decision.
Okay.
That.
Mr. Schwartz?
Well, just to be clear, they will have 15 days from receipt of the notification of the modification.
Yes,
Is it?
that
Okay,
is correct.
okay. Just, and it'll be a start over in terms of their ability to object, and you'll set a hearing based on that.
This is an informal hearing. I do have a question here.
Mhm.
We've got some papers handed to us, Brad, I trust this, but we haven't received it yet.
Right, then you got 15 days from receipt. That's the code, that's the law, so I'm sticking with you, got 15 days. This is the renotice on this particular amendment permit. There's been a change, so this is new notice required. You got 15 days. With that in mind, unless there's any further comments on it, I've made the ruling on it. I will call this hearing officially adjourned and we'll go from there. Thank you.